We're going to talk about healthcare receivables financing. And for those of you that are unfamiliar with this type of financing, it's a common method used by healthcare providers to meet their working capital needs. The healthcare receivable is a healthcare provider's largest and most significant asset, so it's pretty crucial to the lender in form of collateral. So whenever a lender is lending on these healthcare receivables, they're going to want to limit their risk. So how do they do that? Well, the only way to do that is for the lender to become knowledgeable about the provider's practice and the unique aspects of healthcare financing. And when we finish, I'm hoping that you'll have a working knowledge of the potential issues regarding extensions of this type of credit. And why is it important to know all of this? Well, as I just said, this asset is the largest that a healthcare provider has. And under the Affordable Care Act, there's a concern that healthcare providers have that there's going to be a slowdown in payment of their insurance reimbursements from people that are newly signed up under the Affordable Care Act. There is a blog site listed at the bottom of the screen. Back in March, Patrick Warfield from our Nashville office discussed this very issue. I encourage you all, if you haven't joined our creditors sidebar, the blog that the Stites Attorneys and the Creditors' Rights section blogs about regularly, I encourage you to do so. And if you haven't, you can start with Patrick's blog from March. So there are different categories of healthcare accounts receivable from your perspective, from a lender's perspective. There are government collections, Medicare, Medicaid, and any other government program, government healthcare program. Then there's the commercial collections from insurance companies, Humana, Blue Cross, Blue Shield. Then there is the self-pay collections. It is people that don't have health insurance and they're paying out of pocket. Now, under the Affordable Care Act, everybody's got to have insurance, so the self-pay collections should decrease. But for those that don't have health insurance, they're not going to be able to afford to pay a doctor anyway, so these types of accounts are basically non-collectible. So most of these healthcare receivables are going to be classified as accounts under the Article 9 of the UCC, which means that a lender is going to have to file a UCC-1 financing statement on these accounts. Now, of these accounts, there is another section called Healthcare Insurance Receivables, where the provider, the healthcare provider, is going to have an interest or a claim in a policy of insurance. So the provider has a right to the payment of the goods or services provided to the patient, and the structure that the patient and the provider set up is going to be an assignment from the patient. So depending on the source of funding payments from governmental payors, the payments can be classified as an account, and some can be classified as what's called a payment intangible. This is because certain payments from government payors, Medicare, Medicaid, technically cannot be made for services rendered, but they have to be assignments made by so the payment is made to the patient who's entitled to receive the disbursement from the governmental program or the trust accounts, and these are called payment intangibles. So when a lender is looking at these healthcare receivables, how much to loan, lender's going to have to establish a borrowing base, which the lender does for any other type of business. And I can't stress enough that during this time, the lender needs to be educated on what type of service that the provider is giving, what type of accounts receivable the provider has. And there are certain types of accounts receivable they have to be excluded from forming the borrowing base because they are very unlikely to be collected, such as significantly aged receivables, just like with any other business. There's also the self-pay accounts that I just mentioned, because if you don't have insurance and you can't afford insurance, then you're not likely to pay the doctor for your health care services. So once the lender establishes the borrowing base, the lender can hedge against collectability risks and determine what is available under these eligible accounts, and that's how the lender is going to decide how much to lend the healthcare provider. But there is a twist with healthcare providers that you don't have with other businesses. Offsets, recoupments, other contractual program-based reductions that the lender is going to have to think about and kind of forecast what may happen to these accounts that may reduce their value or render them uncollectible. So when the lender is thinking about this, the best thing for a lender to do is establish a type of reserve against this borrowing base that can be adjusted up and down in the event of offsets, recoupment, and other types of government program reductions. One of the big risks is a model called a managed care set up with a capitation payment. And you would think that if there's a set amount each month that a managed care payor is going to give to the healthcare provider, that's steady income that's coming in. But that may not necessarily be true, because a commercial payor has the ability to offset and recoup payments from a healthcare provider if a larger number than expected patients go someplace else for treatment. So if that happens, then in the future, the next couple months, the payor is going to recoup from future payment. And so that means less money is going to come in to the healthcare provider, which would be unexpected. So a way to avoid this is some lenders just refuse to lend on capitation-based models altogether, or they may have a very large reserve required for these types of accounts receivable. But again, the lender has to figure out what type of accounts receivable and what type of models that the healthcare provider has. So to summarize, both the healthcare provider and the lender have to work together, discuss the healthcare receivables that are going to make up the borrowing base, and the collection history. The lender has to know the collection history with respect to these receivables. Another means of managing risk that a lender can do, which is just study the rights that governmental payors have and commercial payors have to affect these reductions I just talked about. And a lender's got to stay on top of this by reviewing the historical track record between the healthcare provider and these third-party payors. So throughout the life of the loan, the lender needs to closely monitor the healthcare provider's collection history in case that adjustments need to be made to the borrowing base and the reserves. So, lender makes the loan. Lender's got to perfect the interest on the accounts. This is done with a financing statement with the Secretary of State in which the healthcare provider is organized. So the lender's security interest is going to attach to the cash proceeds of the collateral when the healthcare provider receives a payment. This does not apply to deposit accounts. For deposit accounts, the lender has to obtain control over the deposit account in order to be perfected. So when does control exist? Well, control exists if the lender is the depository bank at which the healthcare provider comes and maintains the deposit account. Or there's got to be some type of agreement between the lender and the depository bank where the depository bank agrees to follow the requirements and instructions from the lender regarding the disposition of funds without input from the healthcare provider. So this traditional deposit account between the lender and the healthcare provider is great for commercial payors and self-payors, but this does not apply to any payments the healthcare provider is going to receive from the government because of the Medicare anti-assignment rules. So what does a lender do in order to have a full control over the disposition of funds on account. It's pretty complicated, but there's a structure that I'm going to talk about that's set up that the lender can follow to protect itself and make sure that it gets the money that it can. Now, here's something that is another twist. If the lender is the depository bank, all those great rights of set-off that a bank has, they don't apply to these accounts. And the lender's got to expressly waive its right to set off on any funds in the deposit accounts that come from Medicare and Medicaid payments. I encourage the lender to put the waiver in the lender's loan documentation with the healthcare provider. So how does the lender maintain control over these funds? Well, control lies in keeping those funds identifiable. So the governmental payor is going to deposit funds in a designated governmental deposit account that the healthcare provider has. Nothing but the government funds are going to go into that account because the lender will remain perfected as long as the proceeds remain identifiable. And they can do that through the bifurcated lockbox. So the structure I suggest for this lockbox is after the closing, when the healthcare provider sets up the deposit account, the governmental deposit account is only going to be subject to the signing of the authority by the healthcare provider. Lender is hands off. And the provider will have exclusive control of the funds deposited into the account. And the depository bank is subject only to the healthcare provider's instructions regarding the account. Now here's where the lender comes in. Every night, and while it says periodic basis, I recommend every night, the lender sweeps the depository account, pulls those funds, puts it into funds where they can be controlled by the lender only. And so by reducing the amount to zero each day in this type of account, the lender is going to be able to reduce the risk that the healthcare provider is going to redirect or divert funds. However, the provider can rescind the sweep at any time. Now, I was reading in U.S. News and World Report back in December 3 things that doctors should know under the Affordable Care Act. And the last one of those was doctors need to become business savvy if they are not already in their collection methods. I think that the lenders need to stay just as business savvy and stay on top of everything because this puts a huge burden on the lenders to learn about these laws and to make sure that they understand not only the laws but the type of accounts receivable that their healthcare provider has, but that's the only way to keep the lender protected.